What are some key issues involving our jury system? Find out next on Practical Law. Stay tuned. Welcome to Practical Law. I'm your host, family law attorney Henry Gornbein. I'm also pleased to say that Practical Law is now being co-sponsored by the Oakland County Bar Association. Today on Practical Law, we are going to be discussing one of our fundamental rights, and that is the right to a jury trial. Today on Practical Law, I would like to welcome as my guest Gary Krochmal, who is an attorney who is specialized in an area where jury trials are very important. Gary, welcome to Practical Law.
Thank you, Henry.
First of all, why don't you tell our viewers a little bit about who you are and your background?
Well, I've been practicing law in this area for about 40 years. I've litigated cases in the circuit courts, Oakland County, Wayne, all across the state. I have been involved in arguments in the Court of Appeals and in the Michigan Supreme Court. I've litigated in the federal courts in California, in Texas, in Ohio, in Illinois, and in New York. I've argued in the Federal Court of Appeals. I represent clients in litigation matters that they have to bring before the court, or people that are bringing lawsuits against them. I've co-chaired the Medical Legal Committee as part of the Oakland County Bar Association. Half the committee is lawyers, half the committee is doctors. That was a tough co-chairmanship.
That must be very
And I am currently vice chairman of the Oakland County Bar Association Circuit Court Committee. That's a liaison between the Oakland County Bar Association and the bench. So it's interesting work.
Gary, tell us about juries, and there's a long history. What is the bedrock of our jury system, really?
Well, if you take a look at what the Founding Fathers did, you have an idea of the bedrock of the jury system. I'm not a constitutional or a historian in this area, but it's pretty easy to figure out that when our country was formed, the Founding Fathers were very worried about the government imposing their will upon the people. And everything in the Constitution is done to bring the power to the people. So one of the things that they did was they passed the Constitution, and then they passed various amendments, the first 10 of which were the Bill of Rights. And the 7th Amendment is the right to a jury trial. So our Founding Fathers is one of our basic rights, along with free speech, right of assembly, the free press, right to bear arms, said that the jury system is a right that the people have so that they make decisions by themselves about themselves, as opposed to the government imposing their will on this fundamental right.
How do you find that fundamental right today versus, at the time that it was really instituted over 300 years ago?
Well, I find it's every bit as important. And if you take a look at some of the political, I don't want to say unrest, but political involvement that's going on in our country right now, politics aside, the Tea Party, one of their basic tenets is, let's bring back the power to the people as opposed to the government. The Wall Street protesters there's a financial part of that, but there's also this frustration that they have that they are powerless over these financial situations. So the jury system, again, is something where citizens are governing themselves. And it's important now as it was a couple hundred years ago.
What about the fact that a lot of people, when they're asked to serve, don't want to serve?
Everybody hates getting that letter. And for a variety of reasons, they have children, they have a job, they have vacations. Nobody likes getting that letter. But what does happen is when they go through the system, everybody walks away saying, gosh, that was interesting. They feel empowered. They felt that they've committed a public service. They really work hard in trying to do the right thing, as opposed to, we've all heard these phrases, I don't care who he is, I'm going to hang him, or there's frivolous lawsuits, or those darn insurance companies. Everybody who gets on a jury, even though they hate getting the letter, when they eventually go through the process, is proud that they ended up serving.
I think it's one of really the tenets of our society, and it's very important because in so many countries there is no right to a jury trial.
Well, that's true, and I've always looked at it this way. In a system where, look, you can resolve disputes by shooting somebody. You can resolve disputes by a fist fight. I have a great idea on how to resolve a dispute. How about we pick 6 strangers and let them listen to the evidence and make a decision, okay? And it's going to be a random draw. Attorneys don't pick juries. Statistics or just a random nature picks juries. Letters go out, people are called into the jury room, names are drawn out of a hat. It's a very random system. Instead of resolving disputes other ways, here's how it's done. Let's pick 6 strangers, let them hear the evidence, let them make the decision.
It's a random system, but I also know that attorneys will look for ways to cut the odds in their favor, because I've had on this show, I've had a woman who's a handwriting analyst who was in the Kevorkian trials. I had another woman who does face analysis for jury selection, and I've also had a psychologist who does personality profiles and is used as a jury expert. So,
yes, that's true, because every attorney has a duty to use whatever system he can to pick a juror that is as willing to be on his side versus another. Now, what happens is, though, both sides have the right to do that. Sometimes it's done based on, is the case worthwhile? Sometimes it's done on how much money there is to spend on the case. But yes, we all are looking for an advantage to see what we can do to find out whether that juror would be more favorable to my side versus the other side. But we don't pick the jury. What we do is we exclude those ones that we don't like. So again, we're back to the random system. Luck puts 6 people in the jury box. I then can use various analysts, like you mentioned, to take off the ones that I don't think will be favorable to me. Luck then replaces them with another juror. At the same time, the other side is doing the same thing.
Right.
We don't pick the juror, we exclude the ones we don't like. And it's still luck of the draw, because with handwriting analysis, with facial profiles, with body language, with all that, you still don't know what the jury's thinking.
that's true. Gary, what about burdens of proof? I know we have, in a civil trial, you have what is called a preponderance of the evidence, and in a criminal trial, you have that someone has to be found guilty beyond a reasonable doubt. How do you convey that to our viewers and to the jury, really?
Well, the burden of proof is really what it takes for me to convince a juror that I am more right than wrong. That is the civil burden. But that is really what it comes down to. It is what it takes for me, for the juror to decide that my evidence is what the juror needs to make a decision on my behalf. That's the easiest way to do it. As a metaphor, let's talk about, let's say I want to buy a car, okay? And I look at all the different aspects, the price and what style I need, and what the leasing terms are, and what the warranty is, and what the color is. And at some point, I have got all these different decisions, and at some point, I make a decision that that's the car for me. Now, in a civil case, I only have to make that decision on what car to buy, using the metaphor,
Okay.
based on, okay, out of all this, I like that one better. If I liken that to a civil case, It is after the jury has heard all the evidence. And I do personal injury work for the most part. I do medical malpractice work. I do automobile accident cases. I do litigation against store owners who haven't kept their premises safe for its customers. So the jury now hears my client's view of what happened and the defendant's version of what happened, maybe the doctor's. And here's my experts and their experts. And here's witnesses, and here's damage experts. And after they put all that together, how do they decide whether malpractice took place or whether what the damages are? In order for them to make a decision on my behalf, the only burden they have is they have to have liked my evidence by what's called a preponderance of the evidence. Better way to put it, more likely than not, or more right than wrong.
Just shifting the burden of
That's
scales
all.
slightly.
If you take the scales of justice, which is the way we do it, I only have to prove my case by 50.1% versus 49.9%. I just have, the weight of my evidence has to be a little bit more than the weight of their evidence. That's the civil system. More
Gary?
right than wrong.
And what we're going to do, we've reached our first break point, and we're going to discuss the burden of proof in a criminal case, which is beyond a reasonable doubt, which is a much different burden.
It is.
So we're going to take a short break. We'll be right back with my guest, Gary Krochmal, as we discuss issues in jury.
Do you have a legal problem but don't know where to turn? The Oakland County Bar Association can help. The OCBA's Lawyer Referral Service is a place to turn for a local attorney willing to provide a free 30-minute phone consultation to discuss your legal problem. The OCBA services covers many areas of law, including child custody, bankruptcy, and immigration. Nearly 200 OCBA attorneys volunteer their time to answer questions. For more information, call 248-338-2100.
We're back with my guest, negligence attorney Gary Krochmal, as we discuss issues involving the jury system. Gary, before the break, we were talking about the various burdens of proof, and you had really explained the burden of proof in a civil case, and then let's go to the burden of proof in a criminal case where you have beyond a reasonable doubt.
Well, as we talked about, in the civil case, it was more likely right than wrong, which is a pretty simple burden. If I'm tied, I lose. If the weight of my evidence is a little bit more, I win on whatever issue is brought by the court, brought by me. And the defense has the same burden. Whatever defense they're bringing, they have to prove to the jury more likely right than wrong for that issue. Criminal's a little bit different. Criminal is, it has to be beyond a reasonable doubt. And that's pretty hard to define. And here's how the rules really define it. Everybody has doubts in anything that happened. Did I really see that? Did it really happen? What was my perception? But in a criminal case, because the government is the one that is prosecuting, we go back to our founding fathers of being very leery about the government's right and the government's oppression, and therefore they made the rule, not constitutionally, but it's what's developed through common law, of the government has to prove their case beyond a reasonable doubt. You can have a little bit of doubt. Is it a reasonable doubt? No, it's not a reasonable doubt. Therefore, the government has proven their case, okay, because they've proven it beyond a reasonable doubt. And that makes sense because our liberty is I don't want to say it's much more important than compensation, but let's be realistic, it is.
Yeah.
Taking away somebody's liberty is pretty drastic, and therefore the government has this burden for two reasons: because of the value of liberty and because it is the government that is doing the prosecution.
Do you think the juries really follow the reasonable doubt? I think they're pretty conscientious, but...
Jurors work hard. They really do. They have this burden, they have this predisposition that we're going to hang this guy no matter what the defendant, no matter what the government says, we're going to hang this guy, or there's frivolous lawsuits, or there's frivolous defenses, the insurance company is bad. When somebody gets on a jury, they actually pay attention, they really care what they're doing, and they want to walk away knowing that they were fair to everybody in spite of their preconceived ideas.
Gary, let's start with really the beginning of the process. It's happened to me I've actually gotten jury letters, filled them out, sent them back, actually been called in a local jury where I was wiped out immediately because, let's face it, most attorneys don't want attorneys on a jury, but it happens. And I know there have been judges who sat on juries, but take us through the process.
Okay. The person gets the letter that says you have been chosen or summoned for jury duty. And here are some forms to fill out, or please call us and we'll send you the forms. And that's how this starts. And what happens is the person usually says, oh no, how am I going to get out of this? It's just a natural instinct. It's a shame, but it is a natural instinct. And one of the things that you and I were talking about during the break was that they will usually give you one chance to not show up the first time. My opinion is go, because the next time you try not to show up will be your daughter's wedding, will be when a vacation is planned. In other words, get it out of the way. What then happens is they will set up a system for you to call in to see if your jury number is going to be used that day. And if it's not, you're done for the most part. If they say, no, we're not having any juries that day, you're done. If you do show up, you'll go through a jury orientation process at the courthouse. And if you're not called on a jury that day, if you're not placed on a jury, you're done for the day. So it's really one day and out. Okay?
What happens at the jury orientation?
You go into a large room, and they have a jury orientation movie. One of the circuit court judges will come down and speak to you and tell you what a wonderful thing it is that you're doing. And the judges have various ways of doing that. There's Judge Mester.
He used to love it.
Judge Mester is fabulous. You listen to him and you become an American patriot and you are going off to do justice. If he was a World War I sergeant, everybody would get out of the trenches and scale the wall.
He's been on the show a couple times and he just loves doing the jury
He is about as enthusiastic as it gets. And different judges have different demeanors. Some are not as good as Judge Mester, but they all want to welcome everybody and let them know what a fine job they're doing, which they are.
Tell us about the movies.
Well, I was going to try a lawsuit, and I wanted to see what the jury orientation movie was like. So I asked permission, because I didn't want to mix with a jury that I'd be dealing with, although I was a month away. And I sat there, and the movie was, to me, amateurish. It was done about 15 years ago. It was done for a high school civics class, and it kept talking about reasonable doubt. And it said there are various burdens of proof in a trial, and it kept saying reasonable doubt, reasonable doubt, reasonable doubt. Well, I was trying a civil case, and I didn't want this jury to think in terms of reasonable doubt. I wanted them to be thinking in terms of preponderance of the evidence, more likely right than wrong, had I met my burden. So being on the circuit court committee, I brought this to the attention of the committee.
What was the reaction of the judges on the committee?
Well, there is only one judge on the committee at that point, because the committee is made up of Oakland County attorneys, and there's one judge's liaison and from the bench, and there's also the circuit court administrator, Kevin Offner. And they said, well, we'll take a look at that. Okay? And they did. And Kevin Offner took a look at it and talked with the judges. They saw the movie and they said, no, this isn't very good, okay, from the amateur standpoint. And to me, the jury movie should not have been talking about legal issues. It should have been talking about the patriotism of this, what the orientation is, how long you're going to last, how long you're going to be there, what you do, what happens when you go in the courtroom, non-legal issues. And I believe the bench agreed, and I was volunteered or given the task of seeing what other movies there were out there. So I'm a member of the American Association of Justice, formerly the American Trial Lawyers, and I went nationally to see what was out there. I went to the Michigan Trial Lawyers Association, now Michigan Association of Justice, and got some recommendations. Judy Cunningham, who is president-elect of the Oakland County Bar Association, gave me some resources. And I came up with a movie from Eaton County which was generic, it was done, and we were able to get that for $20. If we wanted to do the production ourselves, it would cost
them a fortune.
about $20,000.
Right.
So they've got a new movie there that is generic, and it seems to be getting a very, very good response. So one person made a difference, but it took a lot of other people, our judges, the court administrator, and other attorneys to get it done.
How do they handle the burden of proof issue?
They don't talk about it.
Oh,
No, because it's really up to the attorneys to introduce that to the jury and to the judge to introduce it to the jury. So it's really not necessary in a jury movie. Because when you're in a criminal case, the burden is beyond a reasonable doubt. If you're in a civil case, it's more likely right than wrong, or the preponderance of the evidence. And there's even other cases where the burden of proof is clear and convincing evidence. In will contests, in bank account contests, in libel and slander, there are burdens that it's not just reasonable doubt or preponderance of the evidence. There's something called the attorney that is purporting a certain argument has to convince the jury by clear and convincing evidence. So let's talk about it in the trial, not in the jury orientation movie.
Gary, when you try cases, usually you have a jury trial, but sometimes you waive it and we'll have a judge try the case. What are the main differences from your perspective between a bench and a jury trial?
One of the things that happens in a jury trial is this. When I started practicing law, plaintiffs had the upper hand. They really did. If there was an auto accident case, the jury would, okay, the person's hurt, let's compensate him.
Well, this is one of the best plaintiff's negligence states in the United States.
It was,
for a
it is
number of
now
years.
one of the worst.
Yes.
And so what has happened is I now walk in to a jury trial, and the attorney is probably the least trusted person in the courtroom. And the first thing that I have to do with a jury trial is get them to at least trust me. Okay? And to do that, there are various ways through litigation to do that. Number one, when I'm picking a jury, I don't argue with them. I don't try to bring them down. If they're saying that there are frivolous lawsuits, one of the things that I'll do is say, tell me more, tell me more. Okay? And in order to listen to them and maybe hopefully get them to trust me, that I am listening to them, I want to hear what they have to say. It's the same thing during opening statement to a jury. It is more important for them to realize that I want to present this evidence fairly than it is for me to argue with them or trust them. So that is one of the differences that takes place in a jury trial as opposed to a bench trial. All of that is done away with if I'm just trying a case in front of a judge.
I'm going to cut us now because we've gone over, and we're going to take a break point, and then we're going to go back to the difference with the judge. We'll be right back with my guest, Gary Krochmal, as we discuss issues with regard to juries in our legal system.
Do you have a legal problem but don't know where to turn? The Oakland County Bar Association can help. The OCBA's Lawyer Referral Service is a place to turn for a local attorney willing to provide a free 30-minute phone consultation to discuss your legal problem. The OCBA services covers many areas of law, including child custody, bankruptcy, and immigration. Nearly 200 OCBA attorneys volunteer their time to answer questions. For more information, call 248-338-2100.
We are back with my guest, plaintiff's negligence attorney, Gary Krochmal. Gary, before the break, you were talking about really the major differences in presenting a case to a judge without a jury and to a jury. Why don't you continue with that?
Well, there's a lot of preparation that goes into a jury trial. Preparing questions to ask the jury, which can take hours or days to do. There is preparing the opening statement. There is preparing jury instructions. That's done away with in a bench trial. You can just really present the evidence, and although the judges sometimes want you to come up with what you think the facts should show, there's just a lot less paperwork involved and a lot less time, and you can cut to the chase as opposed to, I hate to say posturing, but it is posturing.
Well, you're selling. I mean, you want a jury to like you. With a judge, they want to really know, is there some merit to the case? Let's get to the facts.
And part of it is, as I talked about before, a lot of juries come in and say, this lawsuit is frivolous. And they have the idea that there are runaway juries, and there's just too much money given out by jury trials. The funny thing is, Henry, all insurance companies ask for a jury trial. When I start a lawsuit on behalf of a client, I never ask for a jury. I save my client $85. It is always the insurance company that pays the $85 for a jury demand. If they don't, then I'll go back. I have 14 days from when they file an answer to do this. But it's the insurance industry that is asking for juries all the time. And it's interesting when they're the ones that saying there's too many jury trials and these are frivolous trials, that they're the ones that are asking for a jury as opposed to a judge.
Interesting point. I didn't know about that. But what are some thoughts that you would like to share with our viewers about, your experiences before juries and just the whole jury system before we sign off the show?
The jury system is so important to our country and to litigation in this area. And it is the very fact that the jury is there that many times makes the case settle, even if they never hear the case, because we are afraid of what they may find. As a lawyer, I'm trying the case based on my plaintiff, the defendant is trying the case based on the defendant, and we both don't know what the jury is going to do. I've tried cases against Amtrak where we settled the case while the jury was out because we didn't know what the jury was going to do. They paid me money, the jury came back and said they would have not given my client any money. So as they say, a good trial lawyer knows the law, a great trial lawyer knows the judge. A good trial lawyer, I like to think, also knows the jury. It was good to settle. We've had questions come back from the jury that have said, can we do this? Can we fine for the driver and not his passenger, when I was representing both? And we said yes, and the jury came back with they found for the passenger and not the driver. You never know what is going on back there, and it is the very fact that there is a jury makes most cases settle on the courthouse steps.
We've run out of time. Gary, I want to thank you so much for being my guest on Practical Law. I want to thank you for watching Practical Law.